Namaste ji, namaste. So let us discuss Smith versus Charles Baker and Sons. But before that, as usual in the LBX series, let us try to connect it to a real life scenario. For example, let us say, before we start off with the case, that you are working on a photocopy machine. You are employed by someone and well, they are asked you to work on the photocopy machine. And let us say the photocopy machine suffers a grave malfunction and it bursts into flames or whatever, and then your hands get burnt and then you sue your employer for damages कि मुझे पैसे दो, I need compensation, what nonsense is this? And the employer comes back with this logic and says, well, hello, this was a machine, you already knew that there was a risk, these are massive electrical machines and anything can go wrong at any point of time, you signed up for this. And you're like, when did I sign up for this? I never signed up for this. The machine has to be in a reasonable fit condition, right? The employer owes this much duty to you. So think about it from a judge's perspective. Let us say that this very case comes to you, the photocopy machine one. What will you decide? Should the employee get damages from the employer or should they not? Now, keeping that in mind, let us start with Smith versus Charles Baker and Sons. In this case, the employee was working on the drill and he was cutting stones. So he was focused solely cutting the stone. This guy, the defendant, is a railway contractor. So with a crane, he was passing stone, as in passing from one point to another. So इनके सिर के ऊपर से जा रहा था stone and then it fell down. So it injured the employee, and then the employee said, well, now, so you have injured me, so pay me damages. And he made a crucial point that I was working, otherwise I would have gotten out of the way. So when you're working on a stone with a drill, you are completely focused here. तो आप नीचे देख रहे हैं ना सारा टाइम और आपके सिर के ऊपर आके कुछ गिर गया. And this guy said, well, hello, in their defense, well, you knew the risk. This is such a dangerous environment. You pretty much knew what you're signing up for. This is an inherent risk, and it's a classic case of our प्यारा नन्ना मुन्ना भाई from our LLB entrance, right? Voluntary non-fit injury, नाम तो सुना ही होगा. So that sounds like a movie डालो, right? Voluntary non-fit injury तो गुंडे ही है हमारे यहाँ पे. तो voluntary non-fit injury was the defense that was taken, and this is why they ask in this LLB entrance. This is pretty much a very common thing to be asked in an LLB entrance, and so you knew. So now, as per the hierarchy of the English courts, the lower court awarded £100 in damages, and one point was noted in this judgment that the machine was not reasonably fit, and this is precisely the most important point of this case law. I'll come to that in a bit as to why. So note this down, and you have to mention it in your answers. So the divisional court, well, the company appealed, it was dismissed, but in the court of appeal, now mind you, we need not enter into how the hierarchy of courts work in England. Well, how do we care? But we have to, if in your answer you want to elongate the answers, you explain this hierarchy, as in explain this process of appeals for specifically this case law. Otherwise, you can skip this as well. You can just say lower court and you can just go to House of Lords. So in the court of appeal, there was no evidence of negligence. They said, no, sorry, defendant will not pay anything. But the House of Lords, that is the highest appellate court in England, well, they said lower court was right in giving this damages. Now, what is the ratio? The ratio was, the Judge Sahab said that, when did the plaintiff agree that I'll be working on a stone and obviously काम तो आप ही का कर रहा है, right? So it is your duty to take reasonable care of your employee, right? I mean, photocopy machine wale example में tied up करें. At least the machine should be like well serviced, well maintained. Then the we'll let go of the employer ना कि कुछ भी कहीं पे भी हो सकता है. But otherwise, how can we let go of the employer like this, right? So the employer owes a duty of reasonable care to provide appliance that is reasonably fit, and on the master rests the duty of reasonable care to maintain in proper condition, so that to maintain what in proper condition? The machinery, so that the employee is not subject to unnecessary risk. He never signed up that a stone is going to fall on his head. Obviously, he knows it's a dangerous situation, but when he's working, when he's solely focused on the object, right? And then due to the employer's carelessness, the crucial point is that you never really maintained the machine. So it was found that the machine was not even reasonably fit to be operated, but still you were using it, thanks to which the injury was caused. Therefore, the onus now is on you. Had this point not been there, this case would have turned out differently. But anyway, not to confuse you at this stage, let us not get into those discussions, because law is not a science, it's more of an art. every case law differs, every decision differs. So instead of going into weird technicalities कि यूं होता तो क्या होता, just focus on writing your answer. You are going to mention all of these facts. You're going to mention, especially elaborate the ratio in your answer, and that's pretty much it. And you're going to talk about voluntary non-fit injuria, and perhaps mention that how rescue cases are an exception to voluntary non-fit injuria a bit. They're like about 4 to 5 lines. Just mention it to the examiner that you know, right? Because voluntary non-fit injuria, the examiner basically the answer in your exam, you have to elaborate a bit to elongate your answer. But this is pretty much the core crux of the case law, and this is it. Yeah. So it may just be very big in your case mat and looks lengthy, but don't worry. It's basically we have to focus on the core crux and then just elaborate on these crucial aspects in your answers. That's pretty much it. Right. Now let us go to I believe the Rajkot wala case, which is extremely important. All right. Now uske andar chalte hain ji. Next one. Right. Take care.